hello to Angela.
Hi, Angela.
Angela responds with a wave. And again, when you speak to Angela. So let's start with question number 1. First of all, Matthew, turn, if you have the textbook with you, turn to page 481 and tell me what the requirements for negotiability are, and tell me if this is a negotiable instrument. So Matthew, if you'll read us the requirements, then Alex, you say yes or no, do we meet that?
Yeah.
Okay, so.
Be in writing.
Is it? Where's Alex? Oh, I'm sorry, you can be Alex today.
Okay.
Is it in writing?
Yes.
Yes. Number 2.
Be signed by the maker or the drawer.
Is it signed?
Yes.
Number 3.
Be an unconditional promise or order to pay.
Is it an unconditional promise?
Yes.
I see no reservations. So yes. Number 4.
State a fixed amount of money.
Let me think about that. Is this a fixed amount of money? What do you say? Sydney? Well, it's $1,000 plus interest, but do I know what the interest is? And do I know how the interest is computed? Yes. So therefore, okay. Number 5.
Be payable on demand or at a definite time.
When do I have to pay this, Sydney? Oh, on demand. So therefore, that's met. And then it's either to...
Be payable to order or to bearer.
And what's the difference, Matthew, in order and bearer?
Bearer is whoever holds it.
So bearer means anybody who has it.
Yeah.
Order means payable to a particular name. Sydney, is this payable to a particular name? A.B. Sharp. Therefore, Sydney, is this a negotiable instrument?
Yes.
Therefore, now that I know that, I guess my next question is, Matthew, what's the answer to question number 1?
A.
A. Sydney, you agree? Question number 2. Sydney and Bijou. It's A, non-negotiable, although it's payable on demand. Well, Sydney, that's a contradiction in terms, isn't it? B, non-negotiable because the numeric amount differs from the written amount. Well, it does. Does it?
Yes.
But, does that matter, Sydney? So therefore, the answer is, so B is wrong. C, negotiable even though a payment date is not specified. Well, Bijou is not specified, that makes it a demand note. And Matthew said it could be either a fixed date or on demand. And negotiable because, well, Sydney, does a guarantee matter? Therefore, the answer to the question, Bijou, is, question number 2, the answer is C. Sydney, you agree. Question number 3. Michael and Anne. Under negotiable instruments article of the UCC, which of the following statements best describes the effect of a person endorsing a check without recourse? Michael, what if the person, does it mean that the person has no liability? What if you forged the note, Michael? What if you forged the note and you said without recourse? And would there be recourse against the forger? Yeah. B, the person makes no promise, maybe. The person gives no warranty protection. And so, Michael, what's the difference in B and C? B says you make no promise. The other one says you give no warranty. So which is the weaker language? B. And D cannot be the right answer because it doesn't convert the check into order paper. To convert the check to order paper, Michael, would require a special endorsement. Therefore, Michael, the answer is B. B is in boy. Question number 4. Megan and Linda. I see the note. Assuming all other requirements of negotiability are satisfied, Megan, this instrument is not negotiable because of the lack of a definite time for payment. Megan, do we have a definite time for payment?
Yeah.
April 20th, right? 5 days after the date, so that's not right. Linda, not negotiable because the amount due is unspecified. But it is, isn't it? C, negotiable because it's secured by the maker's inventory. Well, Megan, doesn't matter. So D, negotiable because it's payable in a sum certain in money. Linda, the answer is
D.
D. D is in dog. And you agree?
Yeah.
Question number 5. Kelsey and Brandon. Jane, a sole proprietor who has in her possession several checks which she received from her customers. Lane is concerned about the safety of the checks since she believes that many of them will bear a paper which may be cashed without endorsement. The checks in Lane's possession will be considered order paper rather than bearer paper and will be made payable to cash. Kelsey, that makes no sense at all. Brandon, you agree?
Mm-hmm.
And then just look at B. B says Ted Dent and endorsed by Ted Dent in blank. And then Brandon, D says bearer and endorsed by Sam Soul in blank. So in both cases we have a blank endorsement. And Brandon, a blank endorsement makes it bearer, and that's what we're trying to avoid. So Kelsey, I hope the answer is C.
Yes.
Is it?
Yes.
Bearer and endorsed by Ken, making them payable to Jane. Or you could say, Brandon, you could say for deposit only to Brandon's account, which is probably what you would do. Okay, question number 6. Colby and Taylor. Bond fraudulently induced Till to make a note payable to Wilt, to whom Bond was indebted. Bond delivered the note to Wilt. Will negotiates the instrument to Monk, who purchased it with knowledge of the fraud and after it was overdue. If Will qualifies as a holder in due course. So, Kobe, this is fraud in the inducement?
Yeah.
That is, the underlying transaction is at issue. Fraud in the inducement, Kobe, is a personal or a real defense? Personal. Fraud in the execution is a real defense. Now my next question is, Taylor, is Monk a holder in due course?
No.
No, because he took the notice of the defect. But, Kobe, tell me about the shelter rule.
That the person that is holding receives the same treatment as the previous holder.
If the previous holder was a holder in due course, then you receive the rights of a holder in due course. Which I think, Kobe, slightly different from what you just said. So let's suppose that Taylor is a holder in due course, and you take with notice if there's a defect, then you have her rights. But then you endorse it to Michael, he doesn't have your rights because he's not taking it from a holder in due course. So shelter rule only applies to one transfer. So now that I know the legal analysis, Taylor wants to answer.
A.
A. Kobe, you agree?
Yeah.
Question number 7. So the question that David asked is whether it's order, bearer, whatever. So let's go through one by one. On the man, the undersigned promise pays the order of Ian Wolf. The original note is order or bearer. Order. And then Ian does a blank endorsement, and so that makes it bearer. And then it's to pay George, so that makes it order, because the only one that can collect from this is George. And then the next endorsement is to Alan, that would also be order. And then, what about the next one? Candace?
It's bearer.
Why is it bearer? What's the difference? What's the difference in this endorsement and this one?
Because there's no additional like.
So there's no special endorsement, it's a blank endorsement, so it's bearer. So now that I know it's order, bearer, order, bearer. Oops. No, actually, David, I skipped one. Let's go back. I skipped one. Let's go back here. Is that a special endorsement? Notice what's the difference in this one and this one? What's the difference in this one and this one? Magic words. This one says to pay Alan, while this one doesn't. So this becomes a bearer. Now that I know the order, then tell me, Candace, which is the correct answer? It's
I had D, but
to order, bearer, bearer,
He's right. Yeah.
which is what we have. So therefore, and again, why is this not, guess I need to learn how to write on the computer. Questions? So just look at the notes for today. And I'm looking for my clicker. Michael, I have a stapler. Did you substitute the stapler for the? Okay. So Cindy writes a check for $1,000, but Katie, and writes a check for $1,000, but fills in a name in the pay to order line. Megan sees the check lying on the table and quickly puts the check in her pocket and inserts her name on it. Megan, I'm shocked. So tell me, Katie, what is this? Is this a material alteration of the check? Okay.
Well, I mean, I didn't pay anything. Maybe it is.
What do you think, Megan?
I'm gonna materially alter it, so yes. So I just stole it, so it's not altered yet, right? I don't really know.
Well, did you change it?
No, I just stole it.
You
Oh, I
ins-
put her name on it, my name on it, her name on
Not her name, your name. So I
it.
think.
So yeah, I altered it.
So I think if she just puts it in her pocket, then she's just picked up paper.
Yeah,
But when she inserts her name on it,
I altered
then you've altered it. So is that,
But, I mean, since I don't have a name, maybe I was gonna make it Megan. Like, how is that still? Since it's
well,
nothing
and
there.
that's a good point, Katie. You're raising an evidentiary question. That is, what was your intent? Of course, if your intent was to put Megan's on it, there's no harm, no foul, and this will never go to court. However, if your intent was to put Sydney's in, then Sydney, what do you think? Then you're pissed. Show some emotion here. She's stolen money from you. Now, what if Katie, she did this? And what did she just do? Actually, I did it, but we're pretending she did it. I changed the 1 to a 2. That would clearly be a material alteration. Now, Bijou, let me see what you're doing. Matt gives a promissory note to you. He pays you in March. So then that means that Bijou, the note is now worthless because it's been canceled. The obligation has been discharged, and then you endorsed it to AJ. So AJ, what is she doing?
trying to give me something that's already canceled.
And presumably she wants you to pay her for it. So therefore that would be fraud in the execution, because she's giving you a note that has already been canceled and she knew that. I tell you, Bijou and Megan, you know, I think Brandon's been a bad example. let the record reflect that Brandon shrugged. Cindy writes a check to Craig for cutting Keith Harrison's hair, all 3 strands. But Keith dies before Craig can do the job. So, Cindy, what do we have here? Is this a negotiable instrument?
Yes.
What do you think, Greg? Did you take it for value?
No.
No, because you haven't done it yet. Therefore, this is not a negotiable instrument because it fails for a value test. Because you haven't done, notice, Sidney, this would be consideration. His promise to cut his hair, Craig's promise to cut Keith's hair, but it's not. Sidney, I was talking to Dr. Winstead and Dr. Harrison. We were talking last night. I don't know why, but we were talking. And Winstead, you know, he's got a nice beard. And he said, you know, it's time to get it trimmed. And Harrison said, I've got some scissors. That was funny last night. Linda signs a promising note to Tellini for a performance at Linda's wedding in 2022. While at the wedding reception, Linda offers to pay Tellini, but Tellini refuses to accept payment because she's so moved by the wedding ceremony. I think in the last example, Tellini, you didn't believe in marriage. Apparently you had a change in heart. 2 days later, Tellini realizes a mistake and demands payment. What do you think, AJ?
I don't think Linda should be legally obligated to pay.
Why?
She refused. Tellini had an opportunity.
And so let's put this in legal terms.
Okay, okay.
Linda has tendered payment, which means she's offered to pay her and Tellini is refused. Therefore, you're right, AJ. But AJ, what if she was drunk at the time?
Then that hinders her with mental capacity.
Then the tender is not effective because Tellini had no knowledge of it. So now, Kelsey, this is not an evidentiary question. That is, A, did Linda actually tender payment? And B, did Tellini realize what was happening? But Katie, fortunately, or maybe unfortunately, in the CPA exam, it's all black letter law. So that means in a CPA exam, it would be take the facts as they are. I think one of the things that, Katie, that people do sometimes is they read in facts that are not here. Yes?
I'm sorry, I missed what we said for those 2.
So here the answer is no,
Okay.
because Linda has tendered payment and it was refused. But here the answer is yes, because why, Tellini? Linda's tender was not effective because you were incapacitated.
Thank you.
Signature liability relates to signature on instruments. Signers of negotiable instruments are potentially liable for amounts stated on the instrument, which makes sense. Primary liability is to the maker, and when I say Taylor primary and secondary liability, what does that mean? If I say you have primary liability and Jody has secondary liability, in English, what does that mean?
I have to pay, and if I can't.
That means I would come after you first, and I would come after Jody only if I could not recover from you. So you have primary, so you have backup. So I try to recover from Taylor, but she flees the country and goes to. It's your example. Where are you going? Timbuktu. And the legal system doesn't work there. So. Okay. Primary liability is to the acceptor, a drawing who promises to pay an instrument when presented for payment. Second liability to the drawers and the endorsers. And I think, Kelsey, that makes sense because the primary liability should be the one that wrote the check. And the secondary liability, because she's the one that started the process moving, well, the secondary liability should be on the endorsers. Secondary liability as to proper and proper presentment. I don't know why I said proper twice. Dishonor, proper notice. Notice of the dishonor could be in any reasonable manner. Notice to endorsers. Unauthorized signatures arises in two situations. Forgery does not bind the principal, but bank may be liable if the bank is negligent. That means, AJ, if Jody, you work in a bank, and the bank has signature cards on file.
Yeah.
Do they ever check them?
No.
Why not?
That's
As a practical matter, if you checked every signature that came in,
a lot of work.
but AJ, as a practical matter, they don't check. So you open a checking account, you sign, and then they've got your signature on file. So as a practical matter, they don't check every signature that comes in because they have no time. But if somebody steals your check and forges it, the bank's liable because they're negligent. So I think that's the price, that's, and the fact that you don't check every signature, but maybe if it was for $10,000, maybe you would, I don't know. But the bank has made a conscious decision. What's our liability if somebody forges a $10 check versus the cost of doing due diligence? And the bank has decided for $10, we'll take the liability. An agent is personally liable, but principal is not unless the principal ratifies, and we'll talk more about agency later. Unauthorized signatures, exceptions, general rule, no liability. If the signature is ratified, and Jody, what does that mean? So somebody steals AJ, Kelsey steals AJ's check, she forges the name, and then AJ says it's okay. Then AJ, you have just ratified, which I think seems fair. If it's negligent, the party, and here, well, I don't know. Kelsey, you steal AJ's check and you sign AJ's name. I said that the bank is negligent because they should have checked the signature. Could it also be argued that AJ's negligent? What do you think, Cindy? How would AJ be negligent? Maybe she went to McDonald's and left her check book there. It's in a public place where it could be stolen. And I think, Jody, if it's $10, you're not, the bank's going to not make an issue of it. You'll just pay the $10. Or assume the, or when I say pay the $10, that means you will reimburse AJ's account. But for $10,000, you lose a customer though. Exception and general rule of no liability is with the holder in due course. Person who forges a check can be held liable for payment by the holder in due course. Generally, if the instrument is forged or unauthorized, the burden of loss falls on the last party to take the instrument. Kayla, is that fair? Probably not, but somebody's got to, so, okay. So, I'm sorry.
Is it last or first? You said last.
I'm sorry, first party.
Okay.
I'm sorry, first party. But I would make the same argument that I'm not sure that it's fair to hold anybody liable, but somebody has to be liable. And the same thing would happen, Katie, with a counterfeit bill. So you're a merchant. What do you sell? Corn. You sell corn. And Candace comes in and gives you a counterfeit $20 bill, and you're the first one that notices it. Who's the loser? You are. But arguably, Jody, that's the cost of doing business. How would you know it's for? It's counterfeit.
I'm pretty good. I recognize them.
Really?
Yeah.
I got 20 in my pocket. I got 20 in my pocket. Will you give me 2 tens for it? The impostor rule, impostor imposes this is a maker and issue an instrument in the name of an impersonated payee the endorsement will be effective, and that makes sense, Katie, from the standpoint of the UCC wants commercial activities to flow. So we talked about signature liability. Now we'll talk about warranty liability. Let's go back to the previous one. Suppose Kelsey performs a service, and Kelsey, you paint Taylor's house. So Kelsey paints Taylor's house. Your roommate, and let's give your roommate a name. Let's call her Sydney. Just make up a name at random. You are aware of the fact that she painted Taylor's house. And then you come in and you tell Taylor, I painted your house, and she writes you a check. So therefore you are an imposter in that you're posing to be not Kelsey, but you're posing to be the painter. Okay. But then if you think about it, who's the bad actor here, Sydney? Come on, confessions go to the soul. Yeah, you are. Transferors, when you make an endorsement, you transfer it to the next party, they certain implied warranties regarding the instrument they negotiate, such as the transfer is entitled to enforce the instrument. But stated another way, Sydney, that means you are a holder and you've got the right to the paper. So you have the right to enforce the instrument, which means that if you endorse it to Colby, he takes over in your stead. Signatures are authentic and authorized. The instrument has not been audited. The instrument is not subject to defense. And the transferor, the person making the endorsement, has no notice of that the maker cannot pay the debt. No notice of its obligations. Parties to whom warranty liability extends to any holder who takes in good faith, which Brandon is not necessarily a holder in due course. For example, if you take a check for payment for a service you're going to render tomorrow, you're a holder, but you're not a holder in due course. Why not? Because you haven't provided value, but you took the check in good faith. So therefore, if the check is made payable from Colby to Michael, and then Michael endorses it to you, then Michael is saying, I have the right to this check, and what I'm giving you is, I think it's similar to the good title that we see with merchants, the warranty of good title. Without endorsement, warranties extend only to the immediate transferee. Recovery for breach of warranty, good faith holder can sue for breach of warranty, notice of the claim made within 30 days. A check is a draft drawn on a bank, basic definitions. A cashier's check is a check drawn by a bank on itself, negotiable on issue. Traveler's check, do people still use those? Use credit cards, you know, debit cards. Certified check. Certified check is a check accepted by the bank on which it is drawn. When a bank certifies a check, it guarantees it, it certifies it, so therefore it immediately charges the drawer's account, therefore the check is guaranteed to be good. The bank-customer relationship. The bank and the customer have two contractual relationships. One is David, the creditor, and the debtor. So David, who's the creditor? So you deposit money in the third bank. What bank do you work for, Jody? So you deposit money in her bank. So who's the creditor and who's the debtor?
I would be the creditor.
Because you have made a loan to the bank. So explain this to me, Katie. I wondered this for years, ever since I took my first accounting course. When the bank debits my account, then my account balance goes down. When they credit my account, my bank balance goes up. But that's confusing to me because I thought for a time that the bank is using different terminology than what we use in basic accounting. Because isn't it true, Ann, that to you, that checking account is an asset? So how come when they debit my account it goes down? Because Katie, what David has told us, to the bank, well, it's an asset to you, to the bank it's a liability. So Candace, the terminology is consistent from the point of the bank, because to debit a liability account makes it go down, to credit makes it go up. You know, and Katie, I wondered that for years. And now I know. They also have a principal-agent relationship, so we had a debtor, Tellini, we had a debtor-creditor relationship. We also have a principal-agent relationship. Tellini, who's the principal? You are, and the agent is the bank. So therefore, the bank will act in your behalf. Kobe, you agree?
Yes.
The bank's duties. When a drawing bank wrongfully fails to honor a check, it is liable to its customer for damages resulting from the refusal. But the bank's duty is not absolute. If the bank properly dishonors the check for insufficient funds, it has no liability to the customer. And I think, Greg, that makes sense. When there's an overdraft, the bank has two options, Greg. Either dishonor the check or pay the check and charge the customer's account. Overdraft protection. This is when the bank promises to honor any overdrawn account, and usually they'll do this for a fee, or if you have a minimum average balance. Now, help me understand this, Jody. You're my banking expert. If I have to maintain a minimum balance, then how is the check going to balance? It's an average balance. Okay, so I can have an average balance of $100, and still on a given day, I could be overdrawn. Another thing I just figured out. Thank you. The bank's duty, stop payment order. This is when the customer provides an order not to pay a certain check. If it's made in writing or electronically, it's good for 6 months. If it's oral, it's good for 14 days. Why, Jody? Why 14 days if it's oral?
Because you don't really have proof that you can't go back and say, hey.
Well, you do have proof, but memories dissipate and so forth. And just to be safe, it's probably good to put it in writing or do it online. So Linda writes a check to Talina on the 17th for singing at her wedding on the 18th. But Sydney, Kelsey, I need a proofreader. So here's what we're going to do. We're either going to change Talini to Sydney or Sydney to Talini. And I think Sydney, no offense, but she's a better singer than me. So therefore, this should say Sydney does not show up. So therefore, I'm sorry, Talini does not show up. Damn. Talini does not show up because apparently, Talini, you're still having second thoughts about marriage. Okay. So, and Linda, you're pissed. So then, on the 19th, you put in an oral stop payment order on the check. Consider the following possibilities. Kayla, Talini cashes the check at her bank on the 10th. Now that's next month. So from the 20th, I'm sorry, the 19th to the 10th, Kayla is how many days? From the time she put in the stop payment order on the 19th to the 10th, is that more than 14 days? Therefore, Kayla, so therefore, will Talini get the money? So Sydney, what should Linda have done?
Put it in writing.
Put it in writing, or even better, not give her the check until she performs. And then hopefully, at the wedding, she'll be drunk and she will refuse it. Same as above, except that lender's bank honors the check. So let me think about this. In this case, the check, the bank does not honor the check. So now, Tellini, who has the cause of action here? Or let me say it in non-legal terms. Who has the reason to be annoyed? Not Linda, because they did not cash the check, but you, because the stop payment order was invalid. So now the bank is liable to you because the bank made a mistake. AJ, you follow that? That is, her stop payment order was ineffective, but they honored it anyway, which means now that they owe Tellini the money. Same as above, except Linda's bank honors the check. Now, Linda, the bank did what they were supposed to do. Okay. We'll do that again. So Linda puts in a stop payment order. It's good for 14 days. Sometime next month, Tellini comes in and tries to cash the check. The bank should cash the check. So what other course of action would Linda have? She could shoot you. But that would not be recommended. Yes?
Could somebody just wait until like the 6 months stop payment order is lifted? I know that's like a stale check. Or not getting close to that, but I mean just to avoid the stop payment, could they just wait?
So the check was written 6 months ago, it's not yet been cashed, and the question is, what is the question?
Could like Tellini just go in and cash it after the 6 months, like if she knew these rules, because the stop payment on like in writing has been lifted?
So to be safe, what should Linda do? She should extend the order.
Oh, you.
But now, Jody, so in this scenario, so the stop payment order is only good for 6 months. She waits till the 7th month, but then it's a stale check. Would the bank cash it? But to be safe, she could put in another stop payment order.
Okay.
But then how long do you do this? And also, Jody, what if the check was 7 months old? You might cash it. What if it was 7 years old?
Most likely not.
Well, what if the cashier's not paying attention that day?
Then it would get in.
Then the cashier would be in trouble. Later the same day, the bank receives Kayla's check to Matt, who's the caterer, and there are insufficient funds to honor the check. So now, Matt, what happens?
So we're drafted.
So now, Matt, you would come after Linda, because she wrote you a bad check. Linda, the bank would come after you. Same as above, except that Tellini, and when I say same as above, I mean same as above here. So I got the things out of order. So this is a reference to here. You put in the stop payment order on the 19th. She tried to cash a check on the 20th. The bank should not cash it. If the bank does, what happens? The bank will replenish the money in your account, and then the bank will come after you. Why would the bank come after her? Why would the bank, Tellini, have a cause of action against you? Similar to insurance. If you're involved in an automobile accident, let's suppose that Harrison hits your car, your $50,000 car. You have one? What did you say you did? Harrison hits your car and totals your $50,000 car. You have insurance, so the insurance company will reimburse you. But is Harrison off the hook? No, because the bank will step into your shoes and will be able to sue Harrison because of the insurance. And here, the bank is going to come after you because of your breach with Linda. So the bank steps into your shoes. in the Linda's shoes. Okay. So now let's discuss the Mills case. So tell me, Kelsey, tell me what the facts are.
So it's two ex-business partners, and it's Mills.
Two lawyers.
Mills is the plaintiff, and he, and Siobhan is the defendant. Lawsuits over payments he made regarding a real estate development project. The plaintiff made a total of $400,000 in payments. The defendant claims the payments were investments in the property, and plaintiff claims that it was a loan.
So we actually have two investments. Investment number one was both of them together, and then C buys out M. That was the first investment.
Right.
Now, the investment number two
Is the real estate.
is the real estate. And this is owned by C.
Yes.
And then, for some reason, M makes payments to C. And how much are they?
400,000.
Almost
390.
400,000. And then, M alleges that this was a,
Loan.
M alleges it's a loan, and C alleges that it's a investment in investment number two.
Yes.
And Katie, some practical advice. Never go into partnership with an attorney. Why? Because he can take you to court with no cost. Because he can represent himself. Now, it seems like a pretty straightforward matter that, and you think, Michael, that if we have, you'd think that if we have a $400 payment, $400,000 payment, you'd think there would be some documentation as to whether it's a loan or whether it's an investment. Now, the relevance of this one suggests that kind of strengthens C's argument that they were business partners together. They were in this partnership, they were in partnership here, and then C's making an argument they're in partnership here. But then, to make it even better or worse for C, did C sign a promissory note?
Yes. After that.
And now C is saying what?
That it's not a valid note.
Okay, now that I've got the facts, I think. The other thing that's interesting about this is that Kelsey, just to get the terminology down, it says, this is in New York, and it says the Supreme Court ruled, but in parentheses it tells you that this is the trial court. And New York is interesting because the trial court is called the Supreme Court. And the rest of the world, Candace, the Supreme Court is the last court. But in New York, the Supreme Court is the first court. So when you say Supreme Court, you could be misled. So the Supreme Court ruled, the trial court ruled in?
That it was an investment. That the note was not good.
Okay, so let's look at the questions. Question number one. Kelsey, read it to us, and then Michael will give us an answer.
If the court had accepted C's claim that M's funds represented an investment, would the result in the case have been different? Explain.
Michael? Yes, because because if it's a loan, then he should be paid. If it's an investment, then okay. So question number two. Brendan, read it, and Megan, give me the answers.
Do the facts in this case support the court's conclusion that M took C's note as a holder in due course? Why or why not?
So Megan, let's go through the steps. To be a holder in due course, you have to be
In writing.
a holder. Well, it has to be a negotiable instrument. So let's go through the requirements for negotiability. Because to be a holder of the course, it's got to be negotiable first. So let's go through the negotiability.
So it's in writing, it was signed by the maker, it's an unconditional promise or order to pay. There's a fixed amount, and it's payable on demand at a definite time and to order of bearer, and then it was taken in good faith.
So it isn't, so we meet all the 8 requirements to be a negotiable instrument. And now, to be a holder of the course, he's a holder, and
He took it in good faith,
took in good faith
he didn't know of any,
for value, and he had no notice of the defect. Now, Kelsey, allegedly the defect is that no consideration was provided, but question number 3. AJ, and then AJ, you can answer the question.
Okay, so how did Bill's status as an HTC affect defense? Assertive defense.
It's easier to say M and C.
C, M, gotcha.
So, AJ, what's the answer?
It didn't affect it, it's still wrong, right?
Well, let's go back.
Okay.
Kelsey, who won and who lost? Tell me my book with me.
Mills one.
Oh, okay, okay. I thought originally it said C1. I was like, oh, I read this all wrong. Okay.
Okay.
So he won because he had a real defense, or, well, he
A
won.
lack of consideration is a personal defense, which would a holder of the course would defeat. Question number 4. Question number 4, Bijou and Greg. Bijou, read the question.
Because they work in the court, automatically won.
So, in this case, who won? Greg?
Defendant?
Mills or C? So in other words, the plaintiff wins because the plaintiff is trying to get the money, and I think the strongest argument, and one of the things to remember is, Megan, the words that you read were written by the court after they made up their minds. Is that right? The words that you read, Taylor, was written by the court after the court had already made up his mind. So, Linda, you see this in tax cases. They will slant the facts to say, we made the right decision. So keep that in mind. But Kelsey, keeping that in mind, also keeping in mind, Kelsey, that we don't have the full transcript and we don't even have the full opinion. But I think the most important thing here is that he signed your note. Very good. See you next time.